Now, the second parable arises out of something I did in 2005 in the #1 court in Canberra. Don't know how many of you have ever been to the High Court in Canberra, but next time you're there, pop in and see us. It's another wonderful thing about our democracy, that the Parliament, and I should say to you, Peter, you have the three branches. You have the tripos here tonight, because the Minister, under our Constitution, must be and is a member of the Parliament. We have a member of the Parliament, a member of the Cabinet and the Executive of the country, and a member of the Judiciary. So we're all three branches, we're all here. But no, he's got to have two hats. I know he's got a third hat tonight. I don't know how often he's going to. I caught him on film with this hat, and it'll be on the internet tomorrow. But he's a good sport. He even posed for a second photograph, so he may live to regret this. Anyway, in 2005, we were sitting in the #1 court, the big court in Canberra, under the portrait of Sir Samuel Griffith, the first Chief Justice, and Sir Edmund Barton, who was the first judge of the court, the first Prime Minister of Australia, and Justice O'Connor, in a case of the Sony PlayStation. This was the case in which Mr. Stevens attempted to get around a technological protection measure which Sony Corporation had put into their PlayStation in order to ensure a limitation which they decided on the use that might be made worldwide of their PlayStation. The popes of old divided the world into two with the Pope's line. Sony, in a gesture to the future, divided the world into three. And so it was that Australia, New Zealand and Europe were in one of their divisions, and Japan in another, and North America in another. And the argument that Mr. Stevens advanced was that he was entitled to manipulate the CD-ROM in order to ensure that he could exercise his rights of ownership of an object, and that the law enacted by the Federal Parliament had not, by its provisions, enacted in Australia a provision that would allow Sony to prevent him from doing so. And we took out our magnifying glasses and we looked very closely at the legislation of the Federal Parliament. We remembered the very great importance of people's rights to use their own property as they see fit, unless Parliament takes those rights away. And ultimately, the High Court, unanimously I think, decided that the Sony claim could not be upheld, and that Mr. Stevens was perfectly entitled to burn his CD-ROM and to get around the technological measure that Sony had placed in its system. Now, the moral of that story is multiple. First of all, very soon after, the United States of America called up the Australia-United States Free Trade Agreement and said, it is our understanding that you will give full protection to technological protection measures, and if you don't give legal protection under Australian law, you've got to do it, and pronto. And the Parliament amended the Copyright Act in order to do just that. But the moral of the story is, first, that people have rights. Those rights include rights to use their own property as they see fit, and rights of fair usage of property, which is the subject of copyright protection, and that courts, independent courts, exist in countries like this to uphold those rights and not to derogate from them unless Parliament makes its law very, very clear, as ultimately it is said it did. Now, it hasn't come back since the law was amended, so I'm not making any predictions one way or the other as to whether Parliament got it right again, but there is an issue. There is an issue as to the extent to which people can take copies and use copies in fair usage of copyrighted material. It's a very important issue of the balance between the protection of copyright and the protection of free speech, free usage, and the use of your own property. But the second moral of the story is that it's an instance that Lawrence Lessig constantly teaches, that we are moving to the point in the world where more and more law will be expressed in its effective way, not in terms of statutes solemnly enacted by the Parliament and sent to the Governor-General for the royal assent, but in the technology itself, what Lessig calls code. Embedded in the code on a multinational basis and effective across borders in a way that couldn't have been dreamt of in the past, will be effective regulation expressed in the technology itself. And this is a very important and very new development. And it's a development that is not in the hands of democratic legislatures, which can set the balances and adjust the competition between free usage and restricted usage, free expression and protection of copyright. This is not going to be done in that way. This is going to be done in big corporations protecting their own interests. And that is another parable I lay before the Minister, because it teaches the lesson that however much we are proud of our democracy and even concerned about the democratic deficit that is inherent in the development of code imposed on us from outside by the technology developers, we have to face the reality of the limitations of what we, a country like Australia, can actually do in controlling the use of the technology, and specifically the use of the internet. France discovered this, as you would all know, in the case about the online advertisement of the sale of Nazi memorabilia. That was the most painful thing in France, and France had laws which were designed to forbid glorification or sale of Nazi memorabilia. But securing the effective implementation of those laws in a technology which is not just something homegrown in France, but is global, really demonstrates the borders at which the power of the single state, except perhaps the United States of America, to control and regulate the use of the internet is limited. And in the United States, the great principle of the First Amendment, Congress shall pass no laws to abridge freedom of expression, freedom of speech and freedom of the press. Congress shall pass no laws is a very absolute principle. It's not a principle we in Australia have basically adopted. We have a more measured, a more nuanced principle in our law, because we recognise that there are values that often compete with free expression. Values such as freedom to secure protection of your reputation, of your privacy, of your honour, of your family. So it's a more nuanced balance in our country. But the important point for us never to forget in the context of the internet is that asserting our values, like France asserting its values in the business of the Nazi memorabilia, is often quite difficult, technically and in reality. in a world of a global technology which doesn't always answer to the democratic voice of individual countries. We have to be modest in our appreciation of what we can do.